this is the conundrum that we all face, which is somebody who actually cares about me and wants to help me and is living his values, versus somebody who is trying to trick me and essentially steal from me and lie to me. Those two
Yeah.
people, they
Yeah.
sound the same. They use the same verbiage. They say the
Yeah.
same things. And so you people in this day and age try to filter a lot of what they're being told with disbelief, with a cynical attitude. And we have to find a way of embracing one another's humanity and not assuming the worst about the other person, unless proven otherwise. And I know that's not what you would normally think a lawyer would say to you, but I got to tell you that the reason that I love
Yeah.
what I do, the reason I enjoy coming to work in the morning is that I feel that I am solving other people's problems that they cannot solve themselves.
That was the voice of Gary D. Nissenbaum. And this is the second part of my interview with Gary. Gary is a lawyer. He works almost exclusively now with digital products, people who are creating products that are in the software space. Thank you so much for listening to today's episode. My name is Jonathan Cottrell. This is Developer T, and my goal is to help driven developers connect to their career purpose so that they can positively impact the people they have influence over. And this introduction kind of discussion that Gary and I were having speaks to that ideal, the ideal that I am walking in to my job and helping people that don't know how to do what I know how to do, and that I can help them in a way that, they don't have to be cynical about the work that I'm doing, and I don't have to be cynical about their perspective of me. This is an ideal working scenario, and I recommend to you that you seek out situations, you seek out opportunities to work with that holistic reality in mind. The idea that you can work without having to be on opposing sides from your client, that you can come to an agreement that is mutually beneficial in most cases. So we talk about that. We talk about a lot of other things more specific to media law in today's episode. And I hope that you enjoy the second part of my interview with Gary Nissenbaum. Of course, if you missed the first part, make sure you go back and listen to it before diving into this one. Now, before we jump in, I do want to mention once again the Interview Week Prep Guide. This is for developers who are looking to, once again, connect to your career purpose. The Interview Week Prep Guide, you can find it at beyondbootcamp.io. It's totally free. And it's going to walk you through exercises that help you uncover your own purpose. It's going to help you uncover your strengths, and it's going to walk you through the process of connecting that purpose and those strengths to the company that you're going to interview with. Go and check it out. Again, it's beyondbootcamp.io, and it's totally free. And I can't wait to hear stories from people who are reading this and then going to interviews and using the ideas, the resources that I've provided there, as well as some of the recommendations, some of the practical tips. Hopefully those things are helpful, even if it's helpful only at like a 5% level, right? If it makes you 5% more likely to become hired, then isn't it worth that extra click? It's totally free, so it's not like, it's not like there's a big monetary barrier. And I do that because I know that there are developers out there who have been able to, up until this point, build their career off the backs of open source, right? So this idea is to open up this information and to try to encourage developers to connect to this soft skills stuff in addition to the hard coding skills that you already have. Again, last time, beyondbootcamp.io. Thanks again for listening. Let's jump into the interview with Gary D. Nissenbaum.
Somebody starts a consulting business, to, let's say, do website or app development, or something similar. What should they do? Should they have a corporation? Should they have a limited partnership or a general partnership? Should they have a limited liability company? If they have a corporation, should it be a C corporation, an S corporation? These terms are confusing. And it's very hard to get a straight answer from
Yeah.
people. And so what you generally do is you go to your friend, you see what they did, and you just duplicate it. The fact is, I'll give you a quick example
Yeah.
of why those are different. A limited liability company will give you liability protection with pass-through income. So on the one hand, you're being protected to some extent from a lawsuit, but at the same time, the money passes through without generally without being taxed. I hasten to add that I'm giving
Mm-hmm.
you
Mm-hmm.
general legal principles. I'm not applying this to any particular state or any particular situation. People should consult a lawyer of their choosing. They shouldn't rely on anything that I'm saying. Now, having given you that disclaimer, the a corporation, a C corporation, you're paying corporate business tax generally. Um, but why would somebody then have a C corporation versus an LLC? Well, I'll give you a quick answer. What if you're trying to have investors and you want to sell them shares of stock? There's no shares of stock in an LLC. If you want to someday go public, an LLC generally
Hmm.
does not go public. A corporation does with shares. So again, there's all these different nuances, and you can't really pull that, at least not easily, from a website. Another example of that is what does somebody do when they're leaving their current employer? Are they allowed to compete? Well, the first thing I say is take a look at what you signed when you took the job. And is there a non-compete clause in there? Well, maybe there is. So it doesn't mean
Hmm.
you can't compete. What it means is somebody has to evaluate that non-compete clause. So let me just give you one example of some of the problems there. I can't tell you how many non-complete compete clauses I review when people want to start businesses and they say, "Am I allowed to do this?" I look at their non-compete clause from their current employment, and it says this person may not service any other customers who such that he would be in competition with me, with the current employer. So the former employee cannot be in competition with the former employer. So a layperson looking at that would say, okay, that's pretty clear. I can't compete. But I look at it, or a lawyer looks at it, and the lawyer knows that
Mm-hmm.
generally speaking, the case law throughout the United States says that the purpose of a non-compete never, never can be to stifle competition. That's not the purpose. And if you say that in
Wow. Yeah.
in the language, if it says we're doing this for the purpose of you not competing with me, that may make it invalid. It may make it invalid. The purpose of it should be to protect the property interests, legitimate property interests of the employer, not to stop competition. So that's an example of something you wouldn't know.
So in other words, they can't take that IP and take it directly to someone who is, they've invested a lot of time. They trusted this employee, that the employee has some information that has been, it's not something that the employee brought to the company. It's something that the company has invested in, and they can't take that IP and just, wholesale hand it over to their new company just because they want to.
That's another good example. The example I'm giving is about taking customers, taking clients. Your example though is excellent.
Ah,
I'm
okay.
glad you
Yeah.
said
Yeah.
that
Hmm.
because that's the next thing, which is did you sign a confidentiality agreement? And how broad is it?
Mm.
And is it covering things that are trade secrets? That's one thing. Or is it covering the things that you need in order to
Hmm.
practice your profession at all? In other words, a thing a developer just needs to do to be a
Yeah.
developer, because if it's overly broad, it can be scaled back. There's a concept in the law called the blue pencil rule. And when I say that, you'll see, but blue pencil, I mean, we're going back decades, right? If not centuries. And basically, what it means is that a court will look at one of these non-competes or confidentiality agreements and such, and if they have an anti-competitive effect or they're unconscionable, the court will not necessarily invalidate it. What the court will do is modify it, like blue pencil it. And so, again, these are not things that are intuitive that you would automatically know. It's something that you really need to go to a lawyer who practices in this area to really understand what your rights are. Um, but having said that, what
Hmm.
the law is trying to do, in a broad sense, is it's trying to foster competition. It's trying to foster capitalism. It wants people
Yeah.
to be able to move around and do their thing.
Yeah. Yeah. Because the system only works when you have two people who are racing, right? Uh, and use there's very politically charged words, obviously, when we start talking about commerce and capitalism and all of the other things that go with it. But if you just strip it back to its basic concept, if I have two or three people and I put them in a room and I say, hey, you know what, I want you to come out with a very good thing, and I give them no incentive, right? I just say, I just want you to do something good. Well, it's very unlikely that I'm going to end up with something really particularly good, because people are not very good at just self motivating. Instead, we have this basic human concept of incentive. We have a basic human concept of survival, right? These are core to who we are. And so if you put them in the room and you say, "Hey, there can only be one winner, and the winner gets $100." How much better, how much better of a result are you going to get, right? So this idea is quite simple. That, hey, you know what? We've actually found that competition, it's not about beating people over the head with, I'm better than you. That's not what this competition is about. Healthy competition is about leveling the entire whole, right? So adding value to the market as a total market, not just adding value to an individual company.
Well, the way I look at it is capitalism, the sense of business competition is the accelerator in the car. The court system and the
Yeah.
regulatory system are the brake. Now, I think the point that's been made
Yeah.
in our political dialogue is that you don't want to always hit the brake because the car will eventually stop. So that's not good. On the other hand, from the other side of the spectrum, if all you do is hit that accelerator, you're going to get into an accident pretty quick. And so it's the concept of balance, the
Oh,
fact
yeah.
that the court system, in my view, is there to create balance so that the system is not moving out of control, that there is some kind of understanding that contracts need to be formed, but there are occasions when contracts need to be broken. There's no right or wrong about that. It's not like you're an evil person if you break a contract. However, there should be compensation. And so the law literally, and I know this is another concept that might be not be counterintuitive, but it's an important one for your audience, is that every law student learns in the first semester of law school that there are two regimes of laws in America. There is contract law, which is the formation and the breach of contracts. And then there's injury law, where people are creating injuries, not just personal injury. It can also be injury by virtue of stealing somebody's intellectual property or taking a trade secret. The concept, though, is that the first one, contract law, you can breach a contract and there's no punishment for that. The courts will not say that you did anything evil or wrong. The courts will simply try to reorient the compensation so the person who suffered because you breached the contract will be duly compensated. Whereas if somebody intentionally severs a right, takes intellectual property, grabs trade secrets, steals intellectual property, things like that, um, that person needs to not just compensate. That person, if it's intentional, may need to be punished. We call it punitive damages. Right. And so these are sort of the concepts where, on the one hand, you have a regime of laws that are simply there to be the referee in the rough and tumble of a capitalist business society, and then the other is a court is there to protect victims, and they're just two different concepts that work in parallel.
Yeah, and the reality is, if you're not careful with any system, including the court, including law, there's going to be someone who takes it and finds the edges, finds a way to turn it into a weapon, right? And this is why it's important to, as a developer, as a company, as a business owner, it's important to think about, to hedge yourself against that kind of threat. Because if you end up in a scenario where you have put in, endless amounts of work and you didn't protect yourself, right? You didn't take the time, for example, to create a simple paper trail, which can go a long way. And even things that you would have an intuition for that could be wrong, like things that you think are protecting you, but actually have no protection value whatsoever. If you're in that position, then it would only make sense for you to take the time to go and talk to somebody like Gary and figure out, okay, you know what, where am I possibly vulnerable that I haven't even thought about yet?
That's right. And I'll give you a great example of the concept you were just alluding to. Cyber squatting. Let's just talk for a moment about cyber squatting. You know,
Yeah.
you're talking about someone having a trademark, some kind of proprietary right in a mark, and then someone else unrelated to them who creates a domain using that trademark in a way that confuses, that makes the public think that it's theirs, not the person that actually owns it. The law will not allow somebody to register a domain name that incorporates a famous mark as long as they have a bad faith intent to profit from it. But here's the thing. Domain registration is not a legal process through the court system. Domain registration is done through other worldwide agencies. I'm sure that you're familiar with that basically make this whole system work. So the court system is saying you cannot use the domain
Wow.
registration to to take somebody's rights in their trademark, which is a system of statutes and laws and judicial enforcement. And so the point is that, again, you have in commercial law what you have in the law that applies to developers generally, to developers who are starting their own businesses, to developers who have to worry about intellectual property rights. You're really talking about a regime of laws that where you're acting as a referee, where you're basically saying people are going to step on other people's toes all the time. That's a bad thing, but we're going to figure out a rational, reasonable way to fix it without the two companies destroying one another. And that's the benefit of using the legal system in a way that's positive and constructive to resolve a dispute without destruction.
Yeah, that's a very good kind of summation. And what you said something earlier that was so inspiring to me. I love this idea that you walk into work and you're empowered by the concept that you're actually helping people do something that they couldn't do on their own. And what people may not realize is that either they're setting themselves up for their own destruction or they're participating in the destruction of another company, right? Because they're not paying attention to, how they're going about doing something, right?
Well, part of it is also that people don't want to upset others and they don't want to make enemies. So a lot of times someone is doing something where they're really going
Yeah.
off the rails. I mean, they are taking a very, very risky strategy, doing something they really should not do that's going to go to a bad place. But the people around them have no interest in telling them that because they know they're going to get a bad reaction. They know this person wants to do it. I and the people who work with me here at Nissenbaum Law Group, we are constantly in the position of telling people what they don't want to hear. And in a funny way, a lot of what I do all day is basically telling people what they don't want to hear and getting people to do what they don't want to do. And it's not that I do it in any coercive way. I have no power to coerce them to do anything. These are people I serve, they're my clients. But it's more along the lines of
Yeah.
I may be the only one in their lives who doesn't have a vested interest in pleasing them, but instead has a vested interest in protecting them.
Hmm.
Right. And so I will give them
Protecting
tough love.
them.
I
Yeah.
have
Yeah.
no
Yeah.
issue telling them that what you're doing is dangerous. Here's the reason. Here's what's going to happen. However, here's another solution. Here's another way of going. And I add that because, it
Hmm.
doesn't take a bright bulb, let's say, to be able to say no. Anybody can say no. That doesn't take a lot of education or a lot of acumen, a lot of experience.
Hmm.
But the idea of saying no, but you can do it this way, or no, but here's the risk, and I'm going to give you three alternatives. They're all at various stages of risk. That is the
Mm.
real, in my opinion, practice of law, where you're not destroying deals. You're rescuing deals. You're preventing them from going off the rails. You're preventing them from going over a cliff. I can't tell you how many times I hear people say, I will not bring a lawyer in to a transaction until the last minute because lawyers screw up deals. Lawyers are always there to say no. It's not accurate. It's not accurate. It's like saying, doctors are fixated on disease. Doctors love disease. So I'm not going to go to the doctor because if I go to the doctor, it'll tell me I'm sick. If I don't go, then I don't have to hear that I'm sick. I mean, the point is you go to a lawyer who can
Yeah.
tell you a way out of a situation that you don't even know you're in
hmm
half the time. And that's really what our goal is.
Yeah, and that happens with, there's a lot of developers who are listening to this right now, and you are in a freelancing situation where you have avoided difficult conversations with your client, like for example, signing just a normal contract. Even if it's a boilerplate, very simple agreement, you didn't want to sign it because of someone once told you down the line at some point that signing a contract or presenting a contract is dangerous. You might lose the client because of what it communicates. It communicates that you don't trust them, or it communicates, that you want to be rigid, or that you're out to, pin them down. And the reality is those contracts, when they're written well and when they're presented tactfully, and those are important, don't get me wrong. The important piece here is not only the contract, but how you present it. But if you don't have that stuff, right? If you're not paying attention to those things, then you almost certainly at some point in your freelance career will get taken advantage of by people who otherwise are well-meaning.
Right. Well, let me give you an example of that. And I want to get away from some of the more technical things that we've been talking and talk about another level to this. Let's talk about when developers are working as independent contractors and they're bidding on work. You're bidding on work and you're signing on that you're going to create a website. You're going to create an app. It's going to have certain functionality. Well, let's talk about that. Let's talk about two things. Number one, how did you describe what success looks like, what you have to do to finish this contract and be done with it? Because if what you said is, I'm going to create a website and it will have the functionality that you need to perform what you want to do in your business, you're signing on to something that may be perpetual and right endless. And it may be that you
Yeah,
did it for a
endless.
flat fee and that flat fee is used up and you're still working there. And then if 5 years from now it needs to be renovated, you're still working there. And it's one of these things where there's an art form to how you describe in a bid document or in a contract with a customer exactly what it is you will and will not be doing on that flat fee arrangement and when you go billable and also hourly billable and when you can pull out and when you can give up on the contract. That's number one. Let me just quickly give you number two.
hmm
Source
hmm
code. Um, how many of these customers who obtain, let's say, website development from a developer realize that or believe that they are literally owning all the code, everything that was used for that website. They own the source code. They own the open source code. They basically they have a complete product because what they see is they see the graphics on a screen. Well, how many of them really understand that the developer is keeping some of that code and is able to use it in other jobs? How many of them, and if they don't understand that, are we going to be in a lawsuit? How many of them realize that some of this was open
Right.
source, and if it's open source, it's subject to the conditions of that open source software? And what people think of in the lay public, of course, your audience knows the difference, but in the lay public, we think, well, open source means free. There's no restriction. I can do whatever I want with it. Absolutely untrue. There are all sorts of conditions on open source software that you have to be very, very careful when you have the open source concept, but to read the terms and conditions to be sure that you're not using it in some way that is going to violate that license. So those are two things that I think we have to sort of educate. Let me put it this way: your audience needs to educate their own customers through perhaps an attorney who's
Mm-hmm.
drafting the document in a way that makes this clear.
Today's episode is sponsored by Fuse. And before we get into talking about what Fuse does, I want to go ahead and tell you that Fuse is offering you a 70% discount on their premium product. This is a brand new thing that Fuse has announced. Now, if you don't know what Fuse does, if you've ever tried to develop a mobile application using the traditional tools like Xcode or Android Studio, then you know that it can be a little bit of a pain. And those tools really haven't changed very much in 10 years or so. Fuse is trying to change that reality for you. They've created a tool that allows you to focus on collaboration rather than writing a bunch of code. And the platform works on both Mac and PC. It's an all-in-one solution, and they've just gone from their beta to their official 1.0 launch. This is a huge deal. Alongside this, they've released Fuse Studio, which is their premium editor. This comes along with the premium plan. This is the paid plan from Fuse. Fuse even tells us that you are very likely to be able to get by on the free plan. So there's no cost in getting started up. You can try this out totally for free. Head over to fusetools.com/plans. Now, if you use the code DT and you do decide to upgrade to that premium plan, which, by the way, it has some excellent tools, some built-in UI, really sophisticated things that Fuse has done with their premium plan. If you do decide to go to that premium plan, use the code DT and you'll get 70% off for the next year. Not just a month of 70% off. It's a whole year of 70% off. Again, use the code DT, and you have to use that code by December 31st of 2017. Thank you so much to Fuse for sponsoring today's episode of Developer Tea. I try to listen to what I think developers are going to be saying when they're listening to this episode. There's two groups of developers I want to address right now in response to the establishing your contract in very clear terms about what you're going to do and what you're not going to do. And you mentioned the language, talking about, okay, I'm going to build you a site that helps you accomplish the goals of your business, and how that can end up in an endless work cycle. So there's two groups of developers. The first group is the group that already has done that, and you're on the other side, and you've learned from pain, right? You've learned from a very difficult and sometimes toxic situation, or sometimes not even toxic, but it ended up ruining the relationship that once was actually very good. You had a great relationship with this client, and unfortunately things went off the rails because expectations were not set out clearly. So the other group is the other group I want to address is the group of people who think that the people you're working with would never do that to you because they're good people. Now, here's the problem with this perspective. You may be 100% correct about those people being good, kind. They don't intend to take advantage of you. They don't necessarily intend, to work you to the bone. The problem is when you don't have clarity of expectations, right? Then it doesn't matter what somebody's intentions are. It doesn't matter how good you think these people will treat you. All that matters is what you promise to do versus what they're asking you to do. And if there's a disparity there, if there's a lack of clarity there, then you walk in not knowing when you're going to walk out.
That's exactly right. And a great deal of lawsuits that could be brought are not brought because the people involved have a good relationship. And they're willing to overlook things
Yeah.
that are not integral to their business and to their goals and objectives. Mistakes, accidents, things happen. No harm was meant. There are many situations like that, and the reverse of that, which is what you're talking about, which is you have someone who has a rather minor grievance, something that's not really hurting them in any meaningful way, although it does state some sort of cause of action. And and they are just going full tilt because they feel that they have been disrespected, that they feel that they have not, they're just not, they've not been treated well, and this is their way of getting back.
Yeah, it is a very emotional thing, right?
That's right. And so a lot of what what I do as a lawyer is I try to understand the emotional valence of what's going on, not just with my own client, but with the other side. And I try to understand that, not so
Yeah,
much
yeah,
so that I can tell the client to immediately settle their dispute and this is ridiculous. I find that that doesn't work because when people are not ready to do that, they don't hear it, they're not ready to hear it. It's a useless exercise that
yeah,
basically, and I may not even be right about it. It may be that something that I'm looking at and I say this is ridiculous. It turns
sure.
out it's very important to that person. I just don't understand completely their industry and what's going on. So I need to be humble in the sense of I can't think for you. I'm not living your life. If you need to go
Yeah,
forward with this, I will help you do that. But on the other hand, at various points, I'll sit somebody down privately and ask them if they think they want to settle it. Ask them if they want me to reach out to the other side, and kind of give them the upside and the downside, and not make the decision for them, but see what they want to do. And I find that that approach seems to work better. These disputes sort of have their own half-life, and there's a point at which they should resolve, and generally do, but not always. And part of my job is to spot that sort of area where people can come together, and then bring them together if they want to be brought together.
yeah, yeah. You mentioned the word humble, and there's actually an episode I did recently about what it takes to be a great developer. And one of the traits of a great developer is rational humility. Okay, so the concept of combining these two words, rational humility, it really what it means is recognizing very tangibly and even just statistically that you're going to end up failing, and there's going to be a lot left for you to learn at the end of every single day of your life, right? At the end of every single project that you involve yourself on, at the end of every single client interaction, there's something that you very well could be wrong about, right? And this is such a key factor to growth and to becoming better at what you do in general. And I really love that you brought up that point that, hey, I may not be able to know exactly what needs to happen in every scenario. And this is true. This is one of the drivers, I think, of cynicism for developers. People who are involved in tech have I think, an unusual amount of cynicism about clients and about the world around them. And I think part of the reason for this is because, quite simply, it's a lack of humility and recognizing that, hey, you know what? I don't actually know everything that's going to happen with your product, right? I don't know your customer as well as you do.
Well, let me give you an example of that. There's one of the things that fortunately our culture and our society has moved away from, thankfully, is untrue concept that if somebody does not speak the language well, if they speak English but in a broken language or broken English, or there's some sort of issue with an accent, that somehow they're not as bright as somebody not intelligent. And thankfully, we've gotten away from that. And obviously, not only is it not true, but there have been so many examples where that is not true at all. And so it's the same thing with professions. When you come to a lawyer and
Hmm.
we're using words that you don't understand, um, if you sit there and you don't want to sound stupid, so you don't want to ask, hey, what does that word mean? What does that word mean? I don't understand what you just said. And instead you just sort of nod your head with a smile, and it looks like you understand what I'm talking about, but you don't want to feel or look silly or stupid. You're doing yourself a disservice. And it's not the way that you should work with a professional. And as a matter of fact, I'll go even further. I think that a professional, a lawyer, a doctor, a CPA, a money manager, has an obligation to check in with you and say, listen, there's no such thing as a stupid question. The only question that's stupid is the one you don't ask me. And please ask me to explain something. And frankly, the way I view what I do is if I explain it to you and you don't understand what I just said, it may very well be that I'm the problem, that that I need to figure out a better way of explaining it. And so that challenges me.
Right.
Again, it doesn't take somebody that bright to just regurgitate what they learned in graduate school. That's just memorization. The challenge is to
Hmm.
step back, understand the big picture, and explain it in a simple way, to give you the macro concept, and only from there move to the micro and get into the
Yeah.
verbiage
Yeah.
so that you understand what I'm talking about. And that's one of the key things, one of the key challenges that I set for myself as a lawyer. No client should walk out of here confused.
Yes, what an excellent, excellent value to hold. And this is actually, you're ringing a lot of bells here for listeners because we talk about that same exact concept on this show. Understanding, becoming an expert in communications, not just knowing a little bit about it, but becoming truly an expert at it. That's a hallmark trait of people who are incredibly good at what they do. Right. This is true of lawyers. This is true of developers. It's true of every profession, almost every profession, particularly knowledge-based professions. Is if you can communicate what you've learned, if you can communicate what you're going to do, if you can communicate an idea, then that idea becomes powerful. Right. That it doesn't have power if it's just locked up in your brain.
And ironically, the area in which I do the most of that is in SEO, in how I market my website, how I'm able to market my services. I may have one line or two lines of print that will come up on a Google search, and it has to convey this incredibly complicated concept of why you should hire me as your lawyer. I mean, that's not a simple thing to explain in maybe 20 words. And so what's interesting is that the digital world again has forced me to learn to explain complicated things in very short bursts of language, which is not what I was trained to do. It's a different approach. Now you can take it
Right.
to the extreme, and everything's a tweet on Twitter, and that's kind of that doesn't work. But my point is
Hmm.
that the idea of brevity, the idea that of going to someone who doesn't know you, doesn't
Yeah.
know your profession, and doesn't even want to, and explain to them how you can be of service to them. That is a part of being human. It's part of understanding that your humanity and their humanity are equivalent, regardless of who has the graduate degree there is or who speaks the same
Yeah.
language or who does the same thing. We're equivalent. We're the same. We're coming from the same place. And if we can hold on to that, and I will tell you, just to wrap that up, that the law actually acknowledges that. There's something called alternate dispute resolution, which is a concept that came about maybe 20 to 25 years ago, and it really took hold. And that concept was that the idea of an adversarial court system where people are hitting each other over the head and having a judge kind of break up the fight and then make a choice, or a jury do that, that didn't work in every case, and that there's another way. And so this concept of mediation, the concept of people who are trained to understand both sides, understand the emotion going on, separate everybody, put them in different rooms, and then shuttle back and forth and see if we can come up with a point of convergence, and then settle the dispute in a way that both sides are unhappy with, but they begrudgingly can accept. That's sort of the definition of a good settlement. And that has taken hold in a way that's unbelievable. In fact, if you're really interested in this, go on Google and look up something called collaborative law. That is the next stage after mediation.
Hmm.
It's something that I've often thought could be applicable to commercial law, but it really hasn't taken hold. It's really something that has been focused on in divorce, which is a different area. And the idea of collaborative law, not to get into all
Hmm.
of it, but this is cutting edge. And it's something that began, I think, in California and has moved around the country in divorce situations. It's that you give complete and total disclosure. You tell each side tells the other everything, and you
Hmm.
make a commitment not to mislead, and you sit down in good faith. And that's why it does so well with the right couple in a divorce situation. So take a look at that if you're interested in this area. It's sort of where the law is moving.
Yeah, that's a very good idea. I think, one of the things that's happening in business, and particularly for developers, we're seeing more and more people working as kind of lone guns, right? Lone hires, freelancing, however you want to look at it. Effectively, very small and usually solo outfits, and sometimes it's one or two or three people. And this has been common. I mean, small business is a common thing. Most businesses are small businesses, just by a simple factor of statistics, right? But on top of that, you're starting to see small companies taking on much bigger jobs. And so because we have a lot of small companies, it's almost like component companies coming together with their various expertise and collaborating on projects. That is a very interesting concept of matching the law to that same, overlaying the law on that same concept.
It's going to be very interesting to see where our nation is going essentially in this. Is the digital world, is the world of information technology, going to show the American culture a different way of interacting that is not as adversarial, that where you have,
Hmm.
it's not a zero sum game, that you don't have a winner and a loser. Is there some way that by adopting some of these concepts of collaboration, some of these concepts of joint venturing, um, the very fact that there is an internet but no one owns it, the fact that there are so many people, this is another thing the lay public doesn't really understand, but your listeners do. There are so many people who enhance the integrity and strength of the internet, and if they were going to want to do this, they could destroy those junctions that are used for the internet. They could slow everything down. Quite the opposite. They sort of have a humanitarian approach, an approach where there's a lack of ownership, but you're doing this for the world. This whole idea of freedom of information. Um, you know, I wonder sometimes if this digital world is going to be the way out from some of the rancor that we have seen in other industries and frankly in our public discourse.
Yeah. Wow. Wow. Very, very big topics, and certainly things that we're going to see affecting, all the way down to our daily jobs, right? But also all the way up to national level policy and international policy. Even all of this is going to change the way we do, the way we do everything, the way we do business, the way we do, the way you work, Gary. It's already changing. It's already changing right before our eyes. So. Gary, thank you so much for your time today. I do have two more questions that I like to ask everyone who comes on the show, and I think they're going to be excellent questions to ask you as well. The first question that I like to ask is, if you and I were to go and have a cup of tea or a coffee and sit down and talk for the first time, what would you hope that I would ask you about?
I would hope that you would ask me about how what things I have gained over the years being an attorney that have changed so that the attorney I was when I got my law degree at the age of 26 and the attorney that I am now is different. What have I learned over the years that my practice of law has changed? Because I think I have learned things, and I think that's part of hopefully being humble in my profession and understanding that I can always improve.
Yeah, that's great. And is there a specific thing, maybe that you can share very quickly before we wrap this thing up?
Absolutely. When I was in my mid 20s and I was first a lawyer, whenever I would be assigned work by the person I worked for at that time, a litigation, I would look at it and I would say, "This is silly. These people should settle." And I would call my client and say, "Listen, I got a great settlement. Let's forget this. Let's just settle this thing and then get the other side in the room." And what I found was that by doing that too early, by doing it when I wanted to do it, as opposed to listening to the client and listening to the adversary and understanding the subtlety, the humanity, what's going on between them. I would I would get a bad settlement essentially. Not horrible. I mean, it was always a reasonable settlement, but I could have done, I
Yeah.
think, better when I look back. And I say to myself, a lot of this is encouraging the client toward the goal, but not forcing that goal. And that has helped me a lot in the way I work with my clients. I work for them and toward their interests. They don't have to accommodate me.
Yeah. Wow. That is such an interesting insight, and that experience is something that I think a lot of people share. It's obviously I'm not doing settlements, but I do realize that there are times when my intuition about the outcome of something, it doesn't even matter if it's correct or not, right? I have that same intuition, that first initial assumption that, hey, you know what, this is kind of silly, right? They don't need that. They need this. They shouldn't use that tool. They should use this one. And if I try to jump ahead, or if I try to make that conclusion too quickly, then I'm skipping the mental processes, and I'm skipping the exploration and discovery that they have to go through to get on the same
That's
page
right.
as me.
That's
And I'm
exactly
trying
right.
to jump ahead in the story,
You learn that in life
and it
generally.
just
You
doesn't
learn
work.
that
It
in
doesn't work.
relationships. You learn that in every aspect of the world in which you interact with other people. It's just that as a lawyer, it's more difficult to learn it at the outset because law school is not necessarily giving you those psychodynamics. It's not really giving you those tools. But over the
Mm-hmm.
years, through trial and error, and I got to say, by watching my clients run their businesses with modern techniques of management and dealing with people, I have learned. I learn from my clients and I learn other ways of handling things. And, there's an old saying that as you get older, you get less smart, which means I'm less certain that I know everything, right? And somehow that's better.
Yeah. Yeah.
That's
Yeah.
there you go. That's even better.
Yeah. You know more about what you don't know. Yes. So true. So, this excellent answer to that question. The second question that I like to ask everyone who comes on the show is, if you had just 30 seconds to give some advice to developers of all backgrounds and experience levels, what would you tell them?
What I would tell them is to read what you sign, which also means read what you agree to by clicking I agree. When you access a website, when you access an app, when you take on a
Yeah.
job, don't just sign something because somebody puts it in front of you and looks at you as if you have three heads because you actually want to read it. Um, don't let yourself be intimidated into signing
Hmm.
something that you're only going to really read once something goes wrong. And now you need to either enforce your rights or or somebody's going to enforce their rights against you. That's not the first time you should be reading the contract that you just signed.
Yeah. Oh, it's very good advice. And hopefully
Absolutely.
it'll keep some people who are listening out of some trouble that they otherwise would have been in. Gary, thank you so much for your time. Where can people go and learn more about what you do, and learn about how they might be able to engage you?
The best way is my website. It's at gdnlaw.com, gdnlaw.com. We have a wealth of information on there about internet law and intellectual property law and all the other areas that we practice in. So please visit our website there, and I hope that it's helpful to you. And thank you very much. You have been a tremendously, really terrific resource for developers throughout the years. And I've heard of your podcast before. It's excellent. And if anything, this interview was just done so well, and you just did a great job. So thank you for making this really a pleasant experience.
Thank you, Gary.
Take care.
Thank you so much for listening to today's episode of Developer Tea. Thank you again to Gary D. Nissenbaum. Of course, you can find Gary's law firm at gdnlaw.com. That's gdnlaw.com. Thank you again to Gary for sharing all of the insights and the personal stories with us. And thank you for listening to Developer Tea. This show wouldn't exist without you, and it only exists so that it can serve driven developers and help them connect to their career purpose. I want to inspire you to connect to that purpose and always be striving to become a better developer so that you can better accomplish that purpose. Thank you so much for listening. Thank you to Fuse for sponsoring today's episode of Developer Tea. Fuse is an all-in-one solution that's going to help you write less code and focus more on collaboration, focus more on the outcome of your application. Head over to fusetools.com/plans to get started for free today. And remember, the code DT will get you 70% off their premium plan for an entire year. fusetools.com/plans. Thank you so much for listening to today's episode. One more thing, no matter what stage you're at in your career, if you think that you could benefit from connecting better to your own purpose, and really everyone can, but specifically if you're a driven developer, in other words, if you care about your career beyond just, what your title is, then I want you to take 2 action steps today. The first one is to go to beyondbootcamp.io and download the Interview Week Prep Guide. Here's a little pro tip. It's not just for interviews. There is some interview-specific stuff in there, but you can skip over that and still get a lot out of this Interview Week Prep Guide. It's about 100 pages long, and those pages are going to go really quick. It's in kind of an outline format, and I really think you're going to love it. Beyondbootcamp.io. And the second thing I want you to do is to open up your podcast app, whatever app this episode is playing in right now, and subscribe to Developer Tea. Of course, only if you enjoyed these episodes. If you didn't enjoy these episodes, then I wouldn't ask you to subscribe. But if you did enjoy them, and if you think this is going to help make you a better developer, then subscribing helps. First of all, it helps you be reminded whenever new episodes come out. And there's a ton of new episodes of Developer Tea coming out all the time. We have 3 episodes a week right now, so it's easy to get behind. The second reason I want you to subscribe is because this helps other developers find the show. So if it's been helpful to you, then maybe it would be helpful to another developer. Thank you so much for listening, and until next time, enjoy your tea.